Continuity. So how long do these things last and how are they ended, right? It's a really important question. You've got this liability. How do you get out of it? So this actually, I'll briefly talk about the Uniform Partnership Act of 1914, just because it actually highlights something a little more fundamental about a shift in the law. So again, Uniform Partnership of 1914 is not the law, not the jurisdiction of this classroom. It's not the jurisdiction of the exam. I just want to bring up this example, not to confuse you, but in order to show you the difference in how the law has changed. So you don't even need to take notes on this, just think about it. Don't confuse yourself with this one. Under the old rule, the one you don't have to write down, if one partner dies or removes himself from the partnership, says, I don't want to participate anymore, the partnership then was legally dissolved. It would no longer be able to exist. If any partner left, that partnership would no longer exist. Anyone could effectively create a dissolution of the partnership at any time. This turned out not to be a horrible thing because let's say there are 7 partners and one leaves. If the others continue carrying on a business, they have sort of formed a new partnership with the 6 members. So sometimes it took care of itself. But this shows an idea of the partnership being completely related to the partners. Under the Uniform Partnership Act, there is no concept of a separate entity. A partnership was entirely of the partners. And so if one partner left, the partnership was a combination of partners. So if one partner left, the partnership would cease to exist. Now, for the rule that matters. For the RUPA 1997 approach, it offers a new possibility, that a partner can disassociate without dissolving the company. This concept of disassociation is saying, I don't want to be involved anymore. It doesn't, by itself, destroy the company. And so what this signifies from a theoretical basis is that under states that have adopted the revised Uniform Partnership Act, which are most states, including Pennsylvania, there's the idea that the partnership has some sort of separate status on its own. It's not quite as separate as a corporation, but it's certainly entangled with the individual people, but there's a little bit of tension there, and the law seems to be moving in the direction of recognizing partnerships as an entity on themselves, that they have some sort of existence beyond merely being an amalgamation of partners. As a result, one partner can disassociate without forcing the partnership to dissolve. And the remaining partners can simply pay that partner his share, and the partnership will continue existing. So this is called a buyout right, and they don't have to dissolve to do it. So a person disassociates, they have a right effectively to force a cash out. So you don't want to mow lawns with me anymore? Fine. You can walk away, and you're entitled to your share. The problem is that usually that's under very contentious circumstances, and it can be hard to get that money, as you can imagine. For any of you who have had a business partnership or a personal, any kind of personal relationship going south where someone walks away, hard to get your stuff back, hard to get paid, hard to get that to work. So you'd have to go to court, but under Pennsylvania law, you can go to court, say, I disassociated from the partnership, I'm entitled to an accounting, so you can actually force a judicial accounting where the court will order that the partnership kind of produce its books and records. An accountant will determine what it's worth. Your share will be evaluated. Your account will be evaluated, how much the corporation owes you and how much you owe the partners. I keep saying the partnership, the business. I'm going to say business. How much the business owes you, and in that way you can force a cash out without causing the partnership to disappear. Yes, many hands. Yes, start here. Start here.
If the partnership doesn't have any liquid assets, are you forced to sell something to pay your share, or can they give you your things back?
That's a good question. Can you actually force the? Because that would be almost like a default. I don't think that under the Revised Union Partnership Act that disassociating can force the remaining partnership to liquidate assets. I think those would be owed and would have to be paid like in terms of like an income stream or something like that. I don't actually know that though, but I think that's right. I think that's right. As opposed to but if it was a full-blown dissolution, absolutely. That would cause a winding up and a liquidation. But since the partnership continues operating as a going concern, no, I don't think it forces a liquidation. That money is owed, but doesn't necessarily have to, because that would cause the business to stop functioning. And I don't think that's the result that the law seeks. Yeah.
What if there's only 2 partners, and if that would meet the definition of general partnership under RUBA, if you just have one person to then.
Okay, so,
partner or-
yeah, it would no longer be a partnership. It would continue existing as a sole proprietorship, sort of default to a sole proprietorship. Okay. Other question over here? Yes.
Can you form a general partnership with an LLC?
Yes, the partners don't have to be natural people. The partners can be other partnerships, they can be LLCs, they can be corporations. So there are many types of, I shouldn't say any entity, but certainly those types of entities can be partners in a general partnership. You can be partners, and in fact, the way that most limited partnerships are organized, as we'll talk about in a minute, the general partner is almost always a corporation to avoid liability to any one person. Yes, you don't have to be a natural person to be a member of a partnership. Yes?
How does get two LLCs doing in a general partnership, how does that affect liability?
So the liability would stop at the LLC level.
Okay.
So that actually would be a sort of an unusual structure, but the LLC would block the liability at that point. So if a dissolution occurs, though, so if a partner, so as I mentioned, under RUPA, a partner who wants out, you don't have to dissolve. The partner who wants out can disassociate, and the partnership has to pay him his fair share, which will be determined by judicial accounting. And I think, as Joanne pointed out, I don't believe that requires a liquidation of the business assets, because that's what happens under a dissolution, which specifically does not happen here. A dissolution, though, or a dissolution and winding up, is when the business stops functioning and it pays off its creditors in their order of priority. So it's going to pay its debts first, and then it divvies up the remaining cash within the partnership or assets. And so those assets and cash will be distributed accordingly. So that's the concept of a dissolution.